Greg and I are going to talk about essentially in the course of and rise down in employment and legal actions that occur. And so I guess my first question is, you've heard all these fact patterns and about these tow motors colliding. What do people think? Is that compensable or is that not compensable? What do you all think? You think it's compensable? I don't want you on my side. You'll see at the hearing that's going to be one of the major arguments today that we're going to talk about is whether that is a compensable situation here. And what you have here is if you have horseplay in a facility and the horseplay results in an injury, and we'll talk about fights in a minute, if you have that scenario, in general that is not a compensable situation because the employee has removed themselves from the course of employment. For an injury to be compensable in Ohio, it has to occur in the course of and arise out of the employment. And if you're racing tow motors, how the hell does that have anything to do with the course of your employment? That's the argument. But there's a problem with this case. What's the problem? Anybody, listen.
Supervisor knew what was going on and didn't do anything about it.
Bingo, buddy. That's a big problem in these cases. If you have a situation where management or a supervisor is either participating or condoning the action here, you can have a problem. Now, in Ohio, there's not a whole lot of authority on this issue, but there is one case, and it's a case involving Coca-Cola. So some of you are drinking their product, but you remember when they came out with 1-0 a while back? Well, they were having a party to celebrate the launch of the product, and they were having a picnic. Well, they were at a resort, and people were canoeing, and the supervisor decided to go down and then get involved and participate and instigate tipping over canoes. Bad idea. And what the Ohio court said is that is a compensable situation. So in this particular case, there's a factual question that would apply here as to whether or not, who do you believe? Do they really condone this? Michael, the supervisor, is going to deny that when we have a hearing today, and you'll see that, but he says he didn't do it. But it's a factual question. There's also a legal question here. Think about this. We have Maize and Blue, which is a staffing company. Joe Wolverine, who the hearing will be on, works for Maize and Blue. Scarlet and Gray is supposedly the company that's condoning this action. Does that apply to Maize and Blue? Does their defense go through to them? It's a different employer. And it's very common, as most of you know today, we have a lot of companies where you have regular employees and then they're staffed by temporary agencies. So that whole issue is there. Now, the other thing that comes up in these cases, and I just want to talk about it briefly, is fights. The law with regard to fights and horseplay is very similar, but it's a little bit different. Typically, you'll have a situation where a fight occurs at the plant. So the question is, do people think fights are compensable? You think fights are compensable? Well, generally, no, if two things. One, what's the fight about? If we're fighting about Heather Harbaugh and Tiff Myers, a girlfriend, a non-work-related situation, that's not compensable. The other issue, unlike horseplay that applies, is who's the instigator? If I come over and I punch you, I start the whole situation, I've instigated the action. I'm not an innocent bystander. If you're not an innocent bystander, then in a fight situation, your claim is not compensable. Now, there's lots of nuances on these things that can go from, can you start a fight, walk away, and come back? Is that compensable? Generally, if you started it and come back, and depending on the time, you still may have a problem getting your claim allowed. There's every variation under the world. These don't just happen in an island. We've had cases where people have been killed. Somebody comes in and shoots somebody. There's a girlfriend fight. Ohio State and Michigan, we had one where these guys were working. It was before the game, and the woman had on a Michigan shirt, and the Ohio State person kicked them. And then it escalated, and somebody broke their arm. So this stuff happens in the workplace very, very frequently. So the bottom line is when you see a tow motor accident or a serious injury, you know, you listen to those facts and initially say, well, what are they talking about? 2 people ran each other on a tow motor at work? How's that not compensable? Well, it isn't necessarily compensable depending on the facts and the investigation you do. And the purpose of these investigations is hopefully give you an idea of the questions you would ask. And we try to make it as realistic as possible if we're calling the employer, talking to the witnesses and stuff. So with that, I'm going to hand the mic to Mr. Denny. Oh, okay.
Okay. All right. This fact pattern is complicated because we have a staffing agency, we have a customer employer, and we have an employee of each involved in a tow motor accident. So the first question is, who is immune from civil liability in this case? Are both employers immune? How about one or both of the employees? Is there any liability outside of the Workers' Compensation Act that could be asserted against any of these 4 parties? Number one, the staffing agency is clearly the employer of Joe Wolverine, right? Clearly has the immunity, okay? They pay the comp, they take care of all the payroll, but they don't have any control over the work that's taking place in the warehouse. And so the question is Scarlett and Gray, are they also immune, even though they are not deemed the employer for workers' comp purposes? And I think the case law in Ohio is pretty clear. As long as Scarlett and Gray is directing and controlling the work of the employee of the staffing agency, they also are immune and protected from civil liability for negligence actions, okay? How about the co-employees? Is one or the other liable in tort for the injuries of the other? Depends. If in fact one of them, and in the facts that we're developing here, if Wolverine really did what the facts seem to be pointing to, and if in fact Beam files a PI case, a negligence case against Wolverine, Wolverine, I don't think, would have immunity because his actions were outside the course and scope of his employment. He was doing things that he shouldn't have been doing, and he left the course of the employment, and the accident did not arise out of the employment. And that is a prerequisite, and I've attached the statutes, for the immunity to apply. So the individual employee could well be liable and subject to suit if it's found and determined that he was screwing around and had left his employment. What other issues are created? Obviously, subrogation. There's lawsuits that are filed 8 months after the accident against the manufacturer of the forklift. Somebody's leg got outside of the compartment. You know, that may well be enough to establish a claim under products liability law in Ohio to make the manufacturer liable. So the self-insured employer, Maize and Blue, the staffing agency who's paying the claim, would clearly have a right of subrogation for the costs of that claim against a third party that may be liable. How about the state fund employer? Does a state fund employer have a cause of action for subrogation in Ohio? No. A state fund employer has to persuade the Bureau to prosecute the subrogation action so that they can recoup the premiums that this particular accident caused them. The state fund employer has no direct cause of action for subrogation under Ohio subrogation statute. And then finally, you've also have VSSR liability and you have intentional tort liability in Ohio. And those are the two exceptions to the immunity. And if in fact there is a specific safety requirement that was violated by Scarlet and Gray using tow motors that were not properly guarded, or perhaps if Scarlet and Gray took off a guard to allow their drivers easy ingress and egress from the compartment, there may well be intentional tort liability and or a violation of a specific safety requirement that would land on Scarlet and Gray. They're an employer, but any employer in Ohio is subject to that liability whether or not the accident occurs in the course and scope of the employment. Questions? Anybody? Yes? No, nothing's that simple.
The question is, and there's going to be a talk coming around on this, and it'll be part of the hearing, is, okay, you test positive for marijuana in Ohio and it's above the threshold. You win, claim's no good, life, you go home. That's basically what you're saying. Not at all that simple. What we have in Ohio is, and we'll go through this, if you have a certain level, even though marijuana has limited legality in Ohio, if you hit the certain level, and if you can show that the person was acting impaired, and that was the talk with Joe about reasonable suspicion and all that stuff, if you can show that, you create what's called a rebuttable presumption, which means is the hearing officer, which will be Mr. Denny in a little while, is supposed to, if he has a brain, find that a rebuttable presumption has been created. Hence, unless they can refute it, we're going to presume that that accident was caused by the usage of the drug. But to get from here to there is hard. Oftentimes, employers just do a drug test. It's their standard practice, and they don't have any evidence of rebuttal presumption. So you can't utilize that. If you can show through a doctor that the proximate cause of the injury was the drug, you can still have the claim disallowed, but you have the burden of proof. They're not going to presume that the guy was intoxicated. So it's a much more complex issue.
And that's why all those questions about what was the speech slurred, were they acting kind of different in the morning at the safety meeting, that's why all those questions were asked, because the employer is trying to create a reasonable suspicion to justify the drug test and to gain the rebuttable presumption. And once you get the rebuttable presumption, the burden of proof shifts to the claimant, and it's very difficult then for the claimant to prove I was not under the influence and it did not cause the accident. So it's really a legal procedural type of thing under point 54 of the code.
Other questions? What about Jim Beam? What do people think on him? Is his claim compensable? We're not going to have a hearing on it. What's his consensus?
He wasn't diagnosed with that problem at the time of the accident.
You're right.
It's going to be a medical defense to his claim, very strong medical.
Important.
Because if you remember the facts with Jim Beam, he went to the medical department, they didn't diagnose anything, as you said. Then they went to the ER, they didn't diagnose anything, as I recall. And then eventually, about a week later, after things get moving, he goes to his doctor and they diagnose him with concussion and post-concussion syndrome. So there's a real question on whether those conditions flow from the injury or the potential litigation in losing your job. You know, I get dizzy if I think I'm losing my job. So, you know,
Right.
things change.
Yeah.
Now, Jim Beam, there's also going to be the same issues with regard to him driving the forklift. Now, the testimony today was not as strong against him being really the cause of the injury or the problem, but there's evidence of that. And the other thing that we won't be able to illustrate completely today, but the credibility of these witnesses, they all have different
And who do you believe? That's the job of an attorney.
ex-girlfriend, current girlfriend, new and ex-girlfriend, nobody knows about this, you name it. In a real hearing, they would all be there and you would cross-examine them and you try to set it up a little differently. The other thing that you'll see is when we do this today, we're going to assume that those statements you saw are all there. Now think about this. There were things that some of those people said I really wouldn't want to present at the hearing. It's not necessarily to my advantage. So sometimes the best thing to do is to have an affidavit or just a statement. But in a situation like this, we've got to give everybody the facts. So what I'm saying is, you have a duty to investigate, present the evidence, but you don't have a duty to put in facts that necessarily are irrelevant or maybe are just going to create an issue. So that's where you really need to think before you just submit. Sometimes people take written statements, recorded statements, the third-party administrator may do that. You get in some real trouble when you just submit those statements. You got to really think long and hard before you just do that.
So during Tiffany's statement, she said that there was other witnesses there, just besides Tiffany and Heather. So why wouldn't?
You would. I mean, realistically, what you would do is, first of all, I probably wouldn't do that on the phone on something like this. We'd probably go out, sit down at the plant, and bring people in that were all involved in something like that. You got two very serious injuries here, and so that's what I would think you do. I mean, there's lots of things that you can follow up on this, but we're trying to give the general overview of the ideas.
Right.
So, what about medical marijuana in this situation? Is there any defense, do you think, because he had a card? That's right. Who does that card have to come from? Even if you have one, what's it mean? What if this came from Michigan?
As I think I got from you guys one time, when he's liable for transporting marijuana across state lines.
Yeah.
I think Carl or one of you guys related that to me one time.
There are lots and lots of potential problems. What about the products liability case? What do people think about that? Ask Greg whether he thinks he can defend that case.
I'd have to know more about the forklift. I was involved in a case.
Was it stand-up? Was it a stand-up?
Well, it was a stand-up with a compartment. And I was involved in a case with a stand-up forklift that had an opening, okay? And the driver, the operator, was backing up, and for whatever reason, another forklift was coming, and she put her leg out and had an amputated lower leg. And she filed a compensation claim. The employer, self-insured employer, had no defense to it. It's a big, big ticket item. And then she also filed a products liability case against the manufacturer of the forklift. And we joined that action, and it was litigated for a long time because the forklift manufacturer had been sued for this reason, for not putting a guard over the back end of the stand-up. They had their reasons, and the plaintiff's attorney, sort of a cottage industry, he had handled a lot of these, and it was a hotly contested issue, and the bottom line is the manufacturer paid a big sum of money, and the employer pretty much got everything they paid in the claim back in that settlement. So it depends on the forklift, it depends on how the setup was, and whether there was any need to put a foot or a leg outside that compartment. It's a dangerous risk that's out there in factories.
Because one of the feet have to be on the pedal.
That's right.
Like a train locomotive.
Right.
You have to be on the pedal because it's moved with a handle.
Right. That's right. So
that came up in one of the discussions. I don't know.
Hey, your turn's over. Let's
I'm
get
on.
moving. Get moving.